sientes que soy mala, porque no me aguanto drama de nada. Dime si bien.
Assalamualaikum and greeting to our instructor as well as classmate. I'm Nura Maina binti Haris. Today our team member will present the concept of capacity the contract as per the Contract Act 1950. In simple term, the capacity of contract include legal aptitude of individual to enter into a valid and enforceable contract. This is an important aspect of contract law as only individual with legal capacity can enter into conduct. In this presentation, we are going to explain all the intricate legal concept of the concept and the essential related to the Contract Act 1950 and provide example as well as related case law.
Before we understand whether a contract is legally valid, we first need to know who has the legal capacity to enter into one. According to Section 11 of Contracts Act 1950, there are three main requirements. A person must be 18 years old and above, be of sound mind, and not be disqualified by law. But what do these requirements actually mean? Let's explore each of them in more detail.
Okay, let's dive into the explainer on contract capacity in Malaysia. Are your signed agreements actually binding? So, if a 17 years old signs a contract for a new motorcycle, is that actually legally enforceable? Well, Section 11 of the Contracts Act 1950 has the answer, strictly defining who's legally competent. The law requires exactly three specific conditions to be fulfilled for legal competence. Let's break them down. First, reaching the age of majority, meaning 18. Contracts signed by minors are usually completely unenforceable. Now, what's really interesting about this slide is the sound mind rule. You got to understand the rational consequences. Yes, even being temporarily unconscious or having a serious mental condition completely remove your legal capacity. The third pillar, you can't be disqualified by law, like bankrupt persons who face specific contracting limitations. And this brilliantly illustrates why our 17-year-old motorcycle buyer lacks legal capacity. They failed that age test. So, by evaluating these three strict rules, is your last agreement legally binding?
Hi, my name is Karthik from Group 5. Okay, I'm going to explain about the case law. Let's look at one of the most important cases on capacity to contract. Mohori Bibi versus Darmodas Kosi, decided by the Privy Council in 1903. Okay, in this case, Darmodas Kos, who was a minor, mortgaged his property to a moneylender named Brahmo Dutt to secure a loan. At the time of this transaction, the lender's agent had noticed that Darmodas was a minor. Later, his mother sought to have the mortgage set aside on the ground of his minority. The Privy Council held that the mortgage was void ab initio, meaning it was void from the very beginning, not merely voidable. Since a minor lacks the capacity to contract, the agreement had no legal existence at all. As a result, the lender could not recover the money he had advanced. Why it matters? This case established that the age of majority is a precondition for capacity under the law. A minor's agreement isn't just something that can be cancelled later. It's void from the day one. That's why the lender walked away with nothing, even though he had given real money. Why an old case still applies? Now, this case was decided in 1903, decades before Malaysia's own Contract Act 1950 existed. But it was decided under the Indian Contract Act 1872, which our Contracts Act 1950 was closely modelled on. Because the wording on capacity is nearly identical, Malaysian courts still treat this case as strong authority today. The key takeaway is this: no capacity, no contract. When one party simply doesn't have the legal capacity to enter into an agreement, the contract fails right from the start. That's all from me.
In conclusion, capacity to contract is one of the most important elements in forming a valid and legally enforceable contract. According to Section 11 of the Contract Act 1950, a person is competent to contract only if they have reached the age of majority, are of sound of mind, and are not disqualified from contracting by any law. These legal requirements are important because they protect individuals who may not fully understand the consequences of entering into a contract, such as minor or persons who are mentally incapable of making informed decisions. At the same time, they provide certainty and fairness to businesses by ensuring that agreements are made only by parties who have the legal ability to fulfill their contractual obligation. The case of Mohori Bibi versus Damadas goes further reinforce this principle by showing that a contract made by a minor is void. This case highlights why businesses and individuals should always verify the legal capacity of the other party before entering into any agreement. Doing so can help prevent legal disputes, financial losses, and misunderstanding in the future. As future professionals, entrepreneurs, and consumers, understanding the concept of contractual capacity enables us to make informed decisions and appreciate the importance of complying with the law, whether we are signing employment contracts, purchasing goods, starting a business, or entering into a commercial agreements. Knowing who is legally competent to contract helps ensures that our agreements are valid, enforceable, and fair to everyone involved. We hope this presentation have given you a clearer understanding of the meaning, requirements, and significance of capacity to contract under Section 11 of Contract Act 1950. Thank you very much for your attention, and we hope you found our presentation informative and useful. Thank you.
Si vienes a mi cama